Erika, if you also want to mention about, asking the questions at the end. Okay.
Perfect, thank you.
I would like to read
my office is being painted on the second floor, so I had to move my computer to the dining room. I don't really care for the background, but I don't know how to put up a background, one of the UNH backgrounds that they have. I'm not sure how to do that. Donna, you'll have to teach me one of these days.
Okay, all right. You can also do a blur of your background if you want.
I'm afraid I'll screw something up here, so I don't want to do that.
Next time, right?
Okay. Kath, would you just monitor the phone for me? Kath? Yeah. Just monitor the phone so it doesn't ring during this. Answer it quickly if it does. Just turn 4, Donna.
Let me know when you want me to start it. Afternoon, everybody. We will get started shortly. We're just letting a few other people join the webinar, but give us a few more, 1 more minute.
Okay. So you had me thinking about my first session. It was 1977.
That was the year I interned, Phil.
Yeah, that's when I started. Richard Tulisano was head of the Judiciary Committee, along with Howard Owens from Bridgeport.
So Howard was my first Senate chair in transportation.
Yeah, I remember that. And then, of course, he became a judge.
Yes, sir. What a wonderful man.
Yeah, very nice man. Both of them.
So we are going to get started. It is about 4:02, and our staff will continue to let participants or students in as we see them joining. First, I want to introduce myself. Erika Nowakowski. I'm the Associate Director for the Tau Youth Justice Institute, and we are very excited to have this webinar today on the Connecticut's legislative process. It's a sort of a 101 on what it takes in the sense of the work that we do here at the Tau Youth Justice Institute, which you'll hear a little bit more, and how we bring multiple stakeholders, partners, system partners to come together to look at best practices in juvenile justice reform and how we can make those recommendations and pass them into legislation. For today, the webinar, we are joined by William Carbone, or Bill Carbone. He is one of the faculty there at the University of New Haven, but also our executive director at the Tau Youth Justice Institute, as well as Susan Keene. She is works at the Legislative Office for the state of Connecticut, committee administrator for the Appropriations Committee. I want to allow just a quick minute for both Bill and Susan to say anything else or introduce themselves beyond what I just mentioned.
I'm just happy to be here, and this is not only a good chance to learn about the legislative process in our state from someone like Sue Keene, who's been working at the legislature for many, many years. But it's also a good chance for our students to learn about this wonderful resource we have on our campus called the Tau Youth Justice Institute. It is partially funded by the state and partially funded through federal and private foundation funding, including the Tau Foundation, but it's dedicated to finding solutions for problems affecting children in the state of Connecticut, in particular problems that bring them into contact with the juvenile justice system. It's a wonderful resource for students as you're thinking about research papers, as you're thinking about learning more about possible careers in this field. So I urge all of you to sign up for the newsletters, for the issue briefs, become familiar with the website. It is really a wealth of information that can really help to inform your learning journey here at the university. And although my title says executive director, the people who really do all the work are the other people who are on this panel, Erika Nowakowski, Donna Fromer, Shantae Monroe, and they are the ones that really run the Institute. And we're really lucky on our campus to have such good, dedicated people working with us. Sue?
Thank you, Bill. I was thrilled to be asked by Donna to be a part of this webinar. I have been doing this work for a very long time, and any opportunity I have to share my knowledge of the legislative process and give an insider view to how bills become a law, I absolutely welcome. So I'm looking forward to presenting today and also having a conversation when you have some questions at the end. Thank you, Bill.
Perfect. Thank you so much. And good segue, Susan. Please, we will at the end of this, we are reserving some time for questions and answers, as we do want to hear from you all. And Donna, just correct me, they can enter questions into the chat.
Correct.
Okay, thank you. You can enter questions into the chat and we will make sure to answer those appropriately at the time. So first up for our presentation is Bill Carbone to provide a little history on the juvenile justice system in Connecticut.
Thank you very much, Erika. And I can speak to you from a pretty unique perspective because I spent many, many decades actually working in the justice system in the state of Connecticut. And I was here during what I would consider the most challenging times in the juvenile justice system in our state, when we really had very little to brag about, all the way through the period of making reforms, which you'll hear about, that now give us a chance to really take some pride in the fact that we have a juvenile justice system that is considered a model for the nation. And one of the statistics that I really like to brag about is the one that shows all 50 states and the extent to which they incarcerate minors. And Connecticut ranks 50th. We incarcerate minors at a rate less than any other of the 49 states, the other 49 states. So we should be very proud of that, but it didn't happen by accident. It happened by very deliberate work over many, many years. So what you have in front of you is a slide that takes us back to the early 1990s and what the juvenile justice system in our state looked like. I can tell you that the juvenile detention system, which is of course the pretrial incarceration for kids in our state, was under federal court judgment at the time. Why did the federal court enter in? Because of challenges about the conditions of confinement, the overcrowding that existed in our system. Overcrowding caused by basically overuse of the punishment that they represented by locking kids up. Conditions that were unsafe. The Bridgeport Detention Center, for example, had been built, decades before, and was small, and it had little room for any other opportunities like education and mental health. Conditions were often unsafe, unsanitary, and overly punitive. So all of this caused the federal courts to become involved in our system and to examine further the quality of education that we were offering kids, for example, who were in the detention system. Education for which they were not even being given proper credits in the school system from which they came. It caused the feds to look at the mental health system, since so many of the kids in our detention centers came in with significant depression, anxiety issues, many of them on psychotropic medications, and yet we're not getting the proper care. And oftentimes we're in fact decompensating, getting worse in the context of our detention system. There also were no alternatives at that time. The courts, in fairness, had very few options. What can they do with a child that was exhibiting some significant problems, that was likely to continue to cause crimes where he left in the community, or children that needed to be evaluated, psychiatric evaluations, substance abuse evaluations? We didn't have any evidence-based programs. Part of the reason for that is, of course, that we didn't have the research in those days that really evaluated the kind of options that, for example, the probation department needs. Things like family counseling, things like programs aimed at getting kids back in school, things to remedy psychiatric problems, drug problems, anger management issues. We did not have such programs at the time. The data systems would not permit us to really understand the full scope of the problem, nor to evaluate even our policies that we were trying to put into effect. And very importantly, at that time, we had a large number of kids who are status offenders, locked up behind bars. Status offenders are kids whose only offenses are because of their age. Things like being truant from school, things like being out of control of their parents, things like running away from home. In those days, you could be arrested for those things and you could be incarcerated in a detention center. And so youth were not being rehabilitated in our system. In fact, there was substantial evidence that they were getting worse. Next slide. A lot of that began to change in the late 1990s. Our judicial branch in the state of Connecticut, of course, created in 1999 the Court Support Services Division that brought together so many of the functions of the court system that oversee children and families and even adults that are under some form of court supervision. I had the pleasure and the honor of being the first executive director of this department and served in it for the next 14 or so, 15 years. So that was really the beginning, I think, of a lot of change. And can we move to the next slide? Perhaps the most significant change came, however, from the legislature. Legislature back in 2014 kind of borrowed an idea that we initially surfaced earlier in order to raise the age in Connecticut. You know, we were one of only 3 states in the United States of America where the age of adulthood was 16. Nearly all the other states used either 17 or 18. And we had the good fortune of having wonderful leadership from Representative Tony Walker, Senator Tony Harp at the time from New Haven. And they led a multi-branch effort. They put together an oversight committee that represented the executive, legislative, and judicial. And they guided us through 4 years of changing the law and gradually increasing the age from 16 up to 18 and gradually integrating services that were appropriate for age appropriate for the children and the families that were involved in the system. For the first time, we had an entity that actually set goals for reform, that not just raised the age, but was committed to evaluating the impact that we were having on things like recidivism, returning kids to school, improve family functioning, and also looking at, for the first time, something that I would have to say continues to be an issue today, and that's disproportionate minority contact. It is better today than it was then. The numbers are far, far fewer, but even today we need to worry because it does exist. And so in 2014, by then, Senator Harp was the mayor of New Haven, but Representative Tony Walker, still in the legislature, decided we needed to take that same model, the oversight model that was established for Raise the Age, and to put it in effect to monitor the system, not just monitor the system, but to set goals for the system, to constantly evaluate it, constantly try to improve, and ultimately to make it a place that was downsized in the sense of fewer kids coming into the system, making sure that we maximized our use of diversion, and of course, do as much as we could to reduce the disproportionate impact. I would have to say that this committee, the JJPOC or the JPOC, as it is well known, has had a profound effect at putting in place a whole series of programs, changing the laws that really now give us a system that we can be quite proud of, a system that where we now have tremendous amounts of data that document the effectiveness of what we are doing. Not only do we have a tremendously reduced number of kids coming into the system, we have improved recidivism rates, we have far, far fewer kids in out-of-home placement. And this is a committee that took the bull by the horns a couple of years ago with one of the most important or one of the most serious problems in the system, and that had to do with the education of those who are coming into the system. And they replaced it with a wonderful new entity in DCF that will be monitoring education. So I would have to say we've gone from being in federal court receivership, in effect, to the point now of having one of the best, if not the best, juvenile justice system in the country. So I think I'll move to the next section of this. And I think, Erika, is that where you come in?
That is correct. Thank you, Bill. And we're going to we're going to go through a few slides. Oh, I'm sorry. Okay. Sorry. I'm just looking at the Shante. For some reason, I'm at, oh, okay. There you go. Thank you. Thank you. I apologize. I didn't see the slide. Perfect. I appreciate it. So as Bill mentioned, you know, those significant reform efforts that happened, you know, prior to the JJPOC established, for example, the raising of the minimum age, excuse me, the raising of the upper age of jurisdiction into, instead of processing those youth, those children really, or young youth, 16 and 17-year-olds in the adult courts, were now being processed if they had contact with the justice system in the juvenile justice courts. The other significant, thank you, this is perfect, Shante. The other significant reform, as Bill mentioned, was in regards to the status offenders, the family with service needs, and decriminalizing those children that were being, you know, referred to the courts for, as Bill mentioned, for truancy, which is not, you know, a delinquency. It's not a crime. There's something else going on at home. If that child is missing school, there's or something else that's going on maybe with that child that they may need some other appropriate educational services, but a referral to the court was not going to provide them with the educational services, or was not the appropriate intervention. And so how do we ensure, you know, as a justice system, that we are appropriately providing services to our children? And so, you know, a lot of significant work happened before even the JJPOC, the Juvenile Justice Policy Oversight Committee. But as Bill mentioned, when that committee was formed, some of the steps that they took to ensure that, you know, as it is titled, oversight. So how do we make sure that we don't take steps back, right? That we move forward, and not only move forward, but even push the envelope even further for ensuring that our children are being appropriately serviced in the right systems if they have contact with them, whether it be the Department of Children and Families, whether it be the educational system, or whether it be, you know, if for some reason they do end up in the Department of Corrections, how do we ensure that they're being appropriately serviced? So one of the things that the JJPOC did was they structured themselves. There was a structure for it created. So the committee itself meets once a month, the third Thursday of the month, and it's something that if you're interested, you can watch on CTN the third Thursday of the month at 2:00. And if it's not being televised live, our recordings are posted on our website so that you can watch them as well. But in order to move the work into action steps of what they wanted to do, the JJPOC wanted to accomplish, they structured themselves, and you know, the structure was to establish goals as to what they were looking to achieve and improve on. So they established at that time in 2015 all through 2018 3 goals, and one of them was to increase diversion of our youth out of the juvenile justice system by 20%, decrease incarceration by 30%, and decrease recidivism by 10%. And I will tell you that, you know, the way in which we did all of these, you know, to achieve these goals, we structured ourselves into work groups that corresponded to those goals, so that we can make sure that the work plans that were established, the task for each of those work groups, for example, the diversion work group focused on community-based services and interventions and practices that would better service those children if they're being diverted from the courts. In incarceration, you know, how do we ensure if a child is being detained in any of these facilities, juvenile justice facilities, that they are getting the appropriate educational services, they're getting the appropriate interventions while in those facilities. And as Bill mentioned, the educational service is vital. So how do we ensure that when they're leaving the incarcerated facility or the detainment, facility, that they transition back to their to education, attached to educational services, back to whether it be the home school, the district that they were in, or to the appropriate educational setting that's better suited for them. So these work groups, that's what they reviewed practices and studies and research, and partnered with content experts in these areas to ensure that we moved forward with recommending practices that would be towards the achievement of these goals of increasing diversion, decreasing incarceration, and decreasing recidivism. And I'll just throw out a quick little fact there, something the JJPOC should be very proud of, and all the members, is that by 2015, we had decreased the referrals, decreased referrals of delinquency by 37%. We had, that's a huge reduction, so overall, we saw these rates of diversion and incarceration going in the direction that we wanted. The other areas of promising reform that the JJPOC focused on, and all of this information will segue to Susan, is that a lot of the work that they also focused on was, for example, limiting the grounds of detention to public safety. Eliminating truancy, which was one of the status offenses under family with service needs, eliminating truancy in defiance of school rules. If schools no longer referred a youth who was missing school to the courts, we don't want to leave them without any resources to support, and we want to ensure that we wrap services around the youth and the family. And so, the diversionary work group focused on partnering up with schools and the community to ensure that there's a community-based diversion system that was readily accessible and available in those communities to provide or re-engage that child back, or that youth back into their school, and work with the schools as partners to get them back there, re-engage back into the school. Next slide. Other areas, again, I already mentioned some of the legislative some of the recommendations that later became legislation through the work of the JJPOC. As we mentioned, the Public Act 17-2 that focused on the removal of truancy and defiance of school rules. So no longer could that child be referred, or that youth be referred to the courts, but referred into the community for services that appropriately reconnected them or re-engaged them back into school. Public Act 18-31, Connecticut Juvenile Training School was one of those facilities really that housed many of our kids. And this was a huge initiative that for many years there was a push to close that facility. That was closed in 2018. And there have been other areas of recommendations that have been gone into law through the work of the JJPOC in regards to what the Department of Corrections and Court Support Services Division of the Judicial Branch should be reporting back to the JJPOC on its use of chemical agents or prone restraints or use of isolation while children or in youth are in those facilities. And so there is an accountability measure, as well as a ensuring like that oversight, that we are regularly reviewing when those incidents are occurring, and as well as reviewing what some of the best practices are to alternatively use versus using chemical agents or prone restraints or use of isolation. Next slide, please. Okay, so just before we move over to Susan, what I want to say is that the JJPOC, the way it does its work is, as I mentioned, we have our structure of work groups. Those work groups are attached to specific areas of targeted reform. So for example, the family with service needs. So how do we ensure that those children who are not going to be referred to the courts are appropriately being serviced in the community? So that work group works for about a period of a year to more in reviewing best practices. What does the research say to how we can better, what are the practices that we should be recommending that maybe are not in Connecticut or are not being used in Connecticut, and how those practices can really push the effort forward to better service our children. And so it could be that it's a recommendation is presented and then moved forward into possible legislation. The JJPOC, in continuing its work, I mentioned in one of the slides, the initial 3 goals that were established through their JJPOC strategic plan focused, again, increase diversion, decrease incarceration, decrease recidivism. Most recently, JJPOC spent a good part of 2021 updating its strategic plan and established new goals. And the first one very much mirrors the initial increase in diversion, which is limiting youth entering into the juvenile justice system, which again is a parallel to increasing diversion. The second goal, reducing incarceration, remain because that continues to be a major goal, especially even though our state has done a great job of reducing incarceration in the juvenile justice system. What we do see is that it is our brown and Black boys who are in the system, in their incarcerated facilities. And so this disproportionate minority contact or racial and ethnic disparity that Bill was talking about is very prevalent. Which then leads to our third goal, reducing racial and ethnic disparities in Connecticut's juvenile justice system. In our initial strategic plan, it was a value statement. And we found that through the work that we were doing, though we continue to say this is something we wanted to achieve, we thought that we just didn't want it to say it. We didn't want it to make it a value statement. We needed to make it as a goal because we were so successful in achieving our other goals. And it's a very targeted place strategy to focus on. The last goal is right-sizing the juvenile justice system. And this is both the lower age of jurisdiction and the higher age of jurisdiction. And most recently, in 2021, we raised the minimum age from 7 to 10 in Connecticut. And again, this is a perfect example. This committee set a goal and said, this is something that we need to strive for, and how do we get there? And if you look at other states across the country, they're raising their minimum age. Some have raised it up to 12. It is something that we are looking to pursue in Connecticut, but the fact that we were able to raise it to 10 just a year ago is a huge step forward towards hopefully in the future raising it up to 12. So again, that's the right sizing of the juvenile justice system on both ends, lower and upper age. I think you can move forward, Shante, next slide. Okay, so as I mentioned, we've set goals. Through those goals, we identify what specific targeted practices we want to improve on, what specific targeted reform efforts we really want to touch, want to make. And so the work groups, typically what they do is they get to work. They start partnering with individuals, start having conversations. It's a pull and pull type of situation where not everybody's on the same page, and so how do we work together to build consensus and demonstrate through data and research that this is the direction in which we should be going towards. And from there, once that research and that data that we can prove to justify the direction we should be going towards, we form recommendations that the JJPOC reviews and votes on to support through a legislative process, which typically starts, depending on the year. It could be a long session or a short session. We are in our short session right now, but I'm not going to go into all those details because Susan can speak to those. But where we are right now, this is perfect timing. The JJPOC just approved the set of recommendations in February, which have been delivered to some of our legislators, and in hopes that we can get it through a legislative process this session. So with that, I'm going to switch it over to Susan, who can then provide you more details about what that looks like.
Terrific. Thank you, Erika. So let's talk about that. Let's talk about how the ideas the recommendations of the JJPOC ultimately become legislation. We have in Connecticut 22 joint standing committees. Our committees are made up of senators and representatives. Unlike Congress, we do not have separate committees for various issues and subject areas. We do everything jointly. And those 22 joint standing committees are constituted for the 2-year term under the legislature's joint rules. One of those committees in the joint rules is the Joint Committee on Judiciary. And judiciary is responsible for, among such topics as the court system, the judicial process and procedures, criminal law, probate court, probation, and parole. Judiciary is a committee of cognizance over those issues. In the joint rules, each committee has areas over which they have jurisdiction or cognizance. And the General Assembly as a whole is made up of 151 state representatives in the House of Representatives and 36 senators in our state Senate. And they are charged with enacting all of the laws, be it the state budget or the recommendations of the JJPOC. Next slide, thank you. So let's talk about how legislation is proposed. Individual legislators have the ability to propose a bill. They get an idea. They go to our nonpartisan attorneys in our legislative commissioner's office, known as LCO, and they put in a request to have a proposed bill drafted. Proposed bills are not fully drafted bills. They are merely a statement in non-legal language that expresses the fundamental idea that a legislator has. I'm going to actually skip down to the last bullet on committee bills. So committee leadership then reviews proposed bills that have been referred to their committee, and they decide which proposed bills they're going to consider for the session, which bills they want to see fully drafted in full statutory language. So a committee will take a proposed bill and vote to draft it into a committee bill. This year, not yet. Thank you, Shante. So this year, legislators are limited constitutionally in what they can introduce as a proposed bill. The second year of a term, the short session, as we call it, is limited to matters of budget and taxation, fiscal matters. But committees are not prohibited. There are no restrictions for what a committee can introduce. So the route that committees take in a short session is not really the proposed bill to committee bill route, but rather the raised bill route. And that's a piece of legislation that originates in the committee on a particular topic. A lot of the legislation that has evolved from the JJPOC has been in the form of a raised bill in the Judiciary Committee. Now, the Judiciary Committee is not bound ultimately by the original draft of the bill, whether it be a committee bill or a raised bill. Before the committee's deadline to report legislation out to the floor of the House or the Senate, they do have the ability to make amendments. And those amendments can either be of a technical nature, sometimes as simple as a grammatical error that needs to be corrected, or committees can make wholesale changes to bills before they report them out, which is a substitute bill. Okay, Shante. So let's talk about favorables or joint favorable bills. Because we are joint committees, The action that committees take to move bills to the two chambers is a joint favorable or a JF report to the floor. As I said, all of the committees are joint, therefore all of our actions, our favorable actions, are joint favorables. Now, the governor has a role in all of this as well, which we'll get into in even more detail in a few minutes. The governor does have the ability to veto legislation that she or he doesn't particularly care for. And that's a veto is an action to reject any legislation that's been passed by both chambers of the General Assembly. Now, the General Assembly can get another crack at that. They have the ability to override a governor's veto by a 2/3 majority in both chambers. And lastly, in terms of the types of bills that committees can consider, there are governor's bills. Because of separation of powers, the governor does not have the ability to introduce their own legislation. So they need to ask the leaders of their party to sponsor legislation, introduce legislation on their behalf. Most of those governor's bills are bills that accompany the state budget and the tax package and bonding. But they are not just fiscal in nature, but they are very substantive in nature too, in terms of changing state policy and either changing existing law or introducing brand new policy. So let's talk about how the public can be involved, because different than Congress, where Congress is very, very removed, they're kind of remote. It's not as though I'm going to write Senator Blumenthal and I'm going to expect a bill to be introduced on my behalf in the United States Senate. With state legislators, with state senators, state representatives, it's more immediate. It's all very local. And so the public has an opportunity to participate in the shaping of state law and policy. Legislators can be reached by calling their offices or sending them an email. There's information on the General Assembly's website that members of the public can access, and to speak with legislators directly. The great thing about the legislative body is that they're made up of my neighbors, your neighbors, somebody who may have coached one of your sports teams or been a scout leader or a teacher, or maybe it's an accountant who's done your parents' books for years. These are people that we all know. And so it's not unusual, I have observed, being in the grocery store, to see my state representative having a conversation with a constituent about an issue of concern to them. So it's all very immediate, and the public has direct access to legislators to share with them their thoughts on legislation that works, and as importantly, legislation that doesn't work. So the proposed bill is going to be sent to the appropriate committee of cognizance, depending on what the subject matter is. And the committee has options. So option one is for the committee to take a proposed bill, as we said earlier, and draft it into full statutory language. The committee may send a bill to a different committee. Sometimes legislators will ask that a committee, that a bill start in a particular committee, and our legislative commissioner's office will honor that request. But when the committee, the receiving committee, reviews the bill, they say, well, yeah, it may have something to do with us eventually, but the key components of the bill really are under the jurisdiction of another committee. And so they will refer that bill to a different committee. And then lastly, they may have bills on a lot of similar bills on the same topic. When I was in transportation, we had many bills, for instance, Route 7 or Route 6, there were a lot of bills that were introduced on the exact same subject. So we would frequently combine or merge bills into one and draft it as a committee bill. And committees always have the option to not take any action at all, in which case a bill is deemed failed for that particular session. Although I do have one word of caution on that. Nothing is ever dead until the gavel goes down on adjournment night, because things can find their way into legislation through the amendment process. So we now have legislation before a committee and they're ready to hold public hearings. Every bill that is ultimately reported out by a committee has to have had a public hearing. And public hearings are so important in informing committees, as I said earlier, on what works and what doesn't work. So committees get input from members of the public, from state agencies, from their colleagues, from advocacy organizations. They get a wealth of information during that public hearing process that helps inform the next step. And once the public hearing process has ended, committees will then start favorable reporting bills. And they can give the bill a JF or a JFS, which is a joint favorable substitute. Sometimes there will be bills on an agenda for which there is not consensus, and sometimes a bill will go down on a roll call vote. As with proposed bills, committees can also give a joint favorable change of reference. So they've done all of the legwork on a bill. For instance, the Judiciary Committee with the JJPOC legislation, they have done all of the policy work on the bill. The bill, however, does cost money in all likelihood, and the bill will be given a joint favorable change of reference to the Appropriations Committee so that the leadership of my committee can then determine whether or not there are resources to put into the state budget to support the JJPOC recommendations. Or, as with proposed bills, committees can do nothing. So here are the players, if you will, from a nonpartisan standpoint that work with our legislators to get bills ready for action in the House and the Senate. Our Legislative Commissioner's Office will review all of the bills to make sure that they are constitutional and that they are consistent with any legislation that's previously been enacted. Legislators also need to be mindful of how much bills cost, not only state costs, but also municipal costs. So our Office of Fiscal Analysis will prepare fiscal impact statements known as fiscal notes on all bills going to the chambers. Our Office of Legislative Research will give a very plain language explanation of what a bill does. And once those three components have been completed, the bill is then ready to go to the chambers for action. And the respective screening committees in each of the chambers will set a date for when bills will be considered. So our bills now are out on the floors of the House and the Senate, and what's happening over there. So the legislators in the House or the Senate can vote favorably on a bill. They can amend the bill and send it back to the Chamber of Origin for their consideration of the amendment, or they can reject a bill. Or, like committees, they are not compelled to take up bills. So there are bills that will die on the calendars of the House and the Senate and in any given session. So once the bill has passed both chambers, it's given by the Secretary of the State to the governor. And the governor has the ability, as we said earlier, to sign a bill into law, to veto a bill, or to do nothing. So when we are in session, the governor has 5 days to either sign or veto a bill. And when the legislature has adjourned and the governor continues to review legislation, the governor will have 15 days to take either of those actions. Should the governor decide not to take an action, to be neutral and let the bill sit on the desk till the clock runs out, the bill then goes into law without the governor's signature. And I think now we're ready for questions.
Thank you, Susan. That is great. You just answered one of my questions that was in my head about when the bill does not get signed by the governor. But I have a follow-up question to that, but I will first, we did get a couple questions on the chat. Earlier, when I was presenting about the reform or the goals that were established by the Juvenile Justice Policy Oversight Committee, we received a question about how those goals are established, or what areas specifically how does the JJPOC determine what direction they're going to go in. So I do want to say, our JJPOC membership itself, the group that's legislatively identified, consists of about 41 members. It's a very diverse group of representation from state agency commissioners, executive directors, nonprofit organizations, advocates, parents, youth directly impacted by the system, whether they have firsthand or secondhand experience, and specifically our legislators. And so part of the work that we do at the Tau Youth Justice Institute is we're constantly looking to them. We ask them questions. We want them to drive the direction in which this reform is going to go. We want them to identify the areas that we need to target. So that's one way in which we establish the direction in which we're going to go in, as well as when we are developing or updating the strategic plan. That is done in a collaborative process. We at the Tau facilitate that process. We meet with the JJPOC membership of the 41 members, as I mentioned, but prior to that, we are also meeting with the work group members, which consists from, one work group can consist of about 15 people to 40 members. And so they, at those work group meetings, are also brainstorming away as to which specific areas they want to target, the goals that they want to establish and propose to the JJPOC, so that the JJPOC can support that direction. So again, it's a very diverse group of representation at the work group level, as well as the JJPOC. And there is a lot of brainstorming that happens where people are coming together to identify. Bill, I see you.
Yeah, I want to just say something about the fact that the Tau Institute is part of the University of New Haven, because this really enables a data-driven approach to the consideration of what the reforms should be and what the process for arriving at those reforms should be. The resources of the university through our professors, for example, Dr. Danielle Cooper, who is our director of research, our students who are in the PhD program and the master's program, and the undergraduates that can contribute to the research to help us to identify opportunities for improvement. And this helps to avoid sort of the gut reaction to problems. I mean, for example, some of the current discussion about car thefts, which everybody is concerned about. Really, we've been able, I think, to draw upon actual data to demonstrate the importance of looking at the facts and not simply responding to sort of the emotion of the event of the crimes that are being committed. And that's been true, I think, throughout the experience that we've had with the JPOC, that they do rely on us for data, for research, and very importantly, for recommendations.
Perfect. And then Susan, we did receive 2 other questions in the Q&A. If you would like to, are you able to see them? And if you would like to answer them, please.
I am. So the first question is, do all states follow a similar bill process, or is Connecticut unique? Do others have long and short sessions in alternating years? Well, the answer to that is it's all over the map in the United States. There are some that are like us. There are some legislatures, holy moly, that only meet once every 2 years. So they're all over the map. Yes. Some committees have joint committees. In some states, some states may have joint committees, but not all of their committees are joint committees. So they may have joint committees on certain issues, and then others committees like separate appropriations and ways and means committees, for instance. So not a clear answer, but we're all over the map. The second question is, how does the requirement to have bills reviewed for racial and ethnic impact come into play in the lawmaking process? So those impact statements are not required for every bill like a fiscal impact statement would be. Legislators have the ability to request of our Office of Legislative Research a racial or ethnic impact statement on any piece of legislation. So those statements are produced by request to our Office of Legislative Research.
Right. So Susan, a question that I had as a follow-up, and then I see our time is coming to a close here. When you mentioned earlier about when the governor does not sign a bill, but that bill comes into law, what's the perception there? Is like I have my own thoughts about that perception, but what's the sort of the perception of that?
Very interesting perception. I mean, one of the most dramatic bills that went into effect several years back was the state budget. Governor Rell, even though Governor Rell had staff negotiating a budget with the legislature, both from the governor's office and from the Office of Policy and Management. So there was what the legislature believed was a compromise budget. Governor Rell, when the budget bill hit her desk, decided she wasn't going to sign it, and she let the state budget go into effect without her signature. So,
in effect, it likely provides some political cover when there are things in the budget that perhaps governors don't agree with, but had to in order to get a compromise.
Yeah.
Out of the.
So I've been staffing appropriations since 1983. It's the only time that a budget went into effect without the governor's signature.
Wow, that was gonna be my next question, because that I could see the impact, right? The perception of that being pretty pretty strong, and so I was just gonna ask what is the history around that? How often do you see that happening? But it doesn't sound like it's often, so that's good.
Erika, can I just add, it's important to note that the annual process of developing recommendations for JPOC really also happens within the context of a multi-year strategic plan that they have approved. So we don't just pull the recommendations out of the air, but rather we look at the goals that they approved over the summer. And it's not just the goals, it's objectives and strategies and ways in which we're going to measure. So they pretty much set out a multi-year blueprint within which the annual recommendations are to be considered. So it's a very dynamic process that happens really all year long with the JPOC, culminating at the end of the year and early in the new year with the development of recommendations.
Yeah, I agree. Susan, there is one more follow-up question.
I saw that, yeah. So from Danielle, was it from Danielle? Yeah, from Danielle. So Danielle, only legislators are allowed to make that request, unfortunately. So if you were interested in seeing that, it would be really incumbent upon you to reach out to your legislator, whether it be your state representative or your state senator, and say, hey, you really ought to get a racial or ethnic impact statement done on this. So that's where the public can bring some pressure to bear on legislators to get the right information before legislators make decisions.
And I think it's important to note here that much of the research that Dr. Cooper has done for the JPOC has identified many areas where disproportionality exists. And that did lead to the establishment of a specific goal by JPOC last summer, and actually the creation of a brand new committee that's been working for the past year on coming up with solutions to that very issue of the disparity in the system.
Well, I am seeing that we are done with our time, and I want to say just a couple of things before we close. Bill mentioned earlier the opportunities that the Town Youth Justice has for students. Every year we are looking for students. We do take on several of them. Our staff each have different targeted focus areas from the particular Juvenile Justice Policy Oversight Committee, the work that you see here. Again, it's not just the legislative piece. That's one of the major parts of this work, but there's multiple arenas in which students can be involved in, for example, work groups, and that's where all of the work is really happening. And if students have an interest in learning more, participating in diversionary efforts in Connecticut, we would assign them to assist and support the diversion work group. If they're interested in reducing incarceration in Connecticut amongst juveniles, we have an incarceration work group. All of these at this time, all these meetings are taking place virtually on Zoom. And so accessibility to these meetings is very much available. But if students are interested in participating in this kind of work, please feel free to contact us. Other areas, as Dr. Cooper mentioned a few times in her question about the racial and ethnic disparity, we do have, as I mentioned, a work group solely focused on that. We have an education work group. So a lot of it, there's lots of opportunities in that arena. We have other projects beyond the JJPOC that we do take students on. If you're interested, I see Donna on the screen here, and you're a good writer and you want to help us in writing our issue briefs and our newsletters. Many of our students have had that opportunity, and it's a great opportunity also to get your name out there as well. And so if you're interested in restorative justice work, we have that as well. So I just want to put in a plug there that we appreciate our students and we want to work with them. It's just a great opportunity. We are on campus. We're a small little office on campus. But feel free to contact myself or any of the Tau Youth Justice staff so that we can set up a time to meet and go over some of the opportunities that are available to you. With that being said, thank you so much, Bill.
Well, just thank you to Sue for joining us this afternoon. We really appreciate the information that you shared, and that it was shared in really such a clear and concise and to the point fashion. It's important to note that this will be available for our faculty to use in classes. It'll be available on our website. We can give it to the Juvenile Justice Club on campus to show at one of their weekly meetings. Some other clubs on campus as well may be interested. So this is something that will help our students to better understand how legislation gets passed and to really understand the depth of the commitment in our state, the commitment that transcends any single branch of government and includes them all to trying to make the juvenile justice system as fair and as decent as possible. So thank you all, and thanks especially to the staff at Tao, because really you're the ones, you're the engines behind all the work that happens in the legislature dealing with the JPOC each year. So thank you all. And thanks to those who joined us today.
Thank you. Thank you, everybody.